Hello everyone, and a very warm welcome to our Women in Sectional Title webinar. It's 11 o'clock on the dot. Today I'm really excited to be joined by one of our exceptionally valued sponsors, ASI Besture. Very often we gloss past insurance matters as the theory and process of how insurance works can often be quite dry and tricky to understand. After today, though, you can be sure that we are going to understand mostly everything that there is to know about insurance and certainly about retaining walls. I think you do need to know that ASI Besture has established itself as a highly respected specialist in the sectional title insurance environment. What distinguishes this company is the understanding that community scheme insurance isn't only about placing a policy. It requires appreciation of the legislation, the structure of the body corporates, the responsibilities of trustees and managing agents, and the practical risks faced by schemes every day. So their specialist knowledge tailored with an approach to commitment to service make them a truly valuable partner in our sectional title industry. Before we get stuck in, let me also thank WeConnectU, our other loyal sponsor. I'm looking forward to being a speaker at their next discussion online as part of their Generation Task Module launch on the 4th of September at 9 o'clock. We'll post more information on our Women in Sectional Title platform shortly. We know also that WeConnectU is a proudly South African company specializing in developing software solutions for the property management industry. They're committed to develop superior solutions, enable seamless take-on processes, and provide dedicated training and support services. We appreciate the loyal input and support of both our major sponsors as well as our managing agents. Of course, we're also looking forward to the NAMA 2026 National Conference, which takes place on the 15th and 16th of October this year. The theme is Back to the Future, and it invites us to reflect on the foundation of community scheme industry while embracing the innovations, challenges, and opportunities that will shape its future. The keynote speaker is Dr. Adriana Marais, a world-renowned futurist, scientist, and speaker, who's going to challenge us to reimagine the future by looking beyond today's limitations. For today, we are speaking about whose wall is it anyway? We're talking about retaining walls, responsibility, and insurance. So to begin with, I'm going to assume that everybody here is hearing this information for the first time. So consequently, before introducing my guests, I'd like us to get to grips with terminology. We're going to be speaking today to a broker, an underwriter, and a managing agent. So to start with, a broker, we know, acts as an intermediary between the body corporate and insurance market. So that broker is the face. They actually probably get all the flack, and they need to have pretty broad shoulders to deal with this insurance industry. The broker shops for the insurance and submits the claim. The broker's got an important advisory and placement role, but the broker is not the party actually providing the insurance cover. Then we've got the underwriter. The underwriter provides the actual insurance and administers the insurance product, and they carry the financial risk. So the underwriter ultimately determines the cover in terms of the policy and pays the claim if covered. And if they don't pay, then they're the bad cop. So there's a delicate dance that plays out between the trustees, the broker, the underwriter, and of course a few other parties in between. And we are lucky enough today to have these important role players with us. So I'd like to introduce you to each one. Our broker is Willie van Wyk, and Willie represents the brokerage ASI Besture. He's a recognized sectional title insurance specialist with over 30 years of experience in the financial services and insurance industry. He heads up the sectional title department at ASI Besture, and is very well known for strategic insight and relationship-driven approach. Hello, Willie, and very warm welcome to you.
Morning, Marina, and thank you very much for the introduction. Looking forward to the session today. and also looking to my fellow panel partners in Doug and Alex. Nice to join the platform with you guys, and thanks of all, Marina, thanks for the invite, and it's a privilege for us as ASI Best to be part of your platform, being Women in Sectional Title, and very much looking forward to unpack this quite challenging topic for us from a broker's point of view in terms of retaining walls. So good morning to everyone.
Thank you, Billy. Could we ask everybody to please put themselves on mute and to remain on mute? Thank you so much. Our underwriter is Doug Haig, who's the Managing Director of CIA Building Insurance, an underwriting agency focused on buildings and community scheme insurance. Doug is a chartered accountant by profession, and he's led CIA overseeing its growth into a leading South African sectional title insurance business built on expertise, service, and long-term partnerships. Welcome, Doug.
Thank you, Marina. Good to be here.
Yeah, great to have you on board. Thank you. Thanks for joining us. Doug's always also very, very helpful whenever we need we've got queries on anything to do with underwriting and insurance. Then we've got Alexandra Klutter, we call her Alex, the Head of Department Community Schemes Division of Status Mark. She's been in property management since 2002 and has completed her Advanced Financial Management course and Paddock's HOA course. Alex, welcome. Great to also see you again. Yeah, well, lovely to have you on board.
I think that's Alex from
right, so let's now examine the interplay. Sorry, could you please put yourselves on mute? Thank you. Let's examine the interplay between these protagonists on the sectional title stage and how they work together to obtain results for their schemes, zoning in on retaining walls. That's the subject for today. So, Billy, I'd like to ask you to start. You're going to take us into a short presentation, and I've got some questions that I'm sure people would like to ask, and I'm going to ask on behalf of those people. So if you'd like to just share your screen and start for us.
Yeah, thank you for Marina. Just firstly, I just want to apologize for my camera. Something went wrong on this side. It was working earlier, but now it's not working. But yeah, I'll share my photo at some stage with everyone so that you can see who I am and what I look like. Thanks, Marina. Let's start sharing. In terms of and where I'm going to start is, I think it's a good starting point to share what a retaining wall looks like. And I think that's the big question for everybody walking around to these schemes is say, for trustees and directors, do I really have a retaining wall or don't I have a retaining wall? So let's just start and do screen sharing. Our technology is always on our side and sometimes it's not on our side.
Would you like us to do that, Vili?
Have you got it on that side,
yeah,
Marina?
We've got the slides. Maybe we can just
if you don't mind.
No problem at all.
I have sent it through to you, so if you want to share, I wouldn't mind.
Okay. I think it's a really great idea to share pictures because even before this webinar, before this webinar, I haven't actually seen every single type of retaining wall that you can have. So these pictures are going to be really useful. Okay, go for it.
All right, so images of retaining walls. There are loads of images on retaining walls, and I'm sharing just quite a few so that you can keep it in the back of your mind as we go through the session today, what a retaining wall looks like. And what a clear identification on these images is there is a difference in ground level. And this is where retaining walls play a huge role in terms of the difference in ground levels. The most important one for me is on the right-hand side on my screen, which is the flower boxes. Now, as simply as a flower box could potentially become a retaining wall. A lot of people are building swimming pools and they excavate grounds and they're doing some backfills to walls, building these lovely flower boxes. And at the end of the day, that flower box can potentially be a retaining wall. And once you get a big storm, you could potentially land up with that wall not being covered. So keep this in the back of your mind as we go through. There will always be a difference in ground level if you do look at retaining walls. And if we quickly jump into the next slide, the definition, which is very important for us to look at, the definition of a retaining wall is a structure that is designed and constructed to hold back soil, rocks, or other earth materials. Where there is a change in ground elevation, the primary purpose is to prevent the soil behind it from collapsing, sliding, or eroding. So that is the function of and the definition of a retaining wall. Simple definitions of a retaining walls, and as we can actually go through, it's supporting slopes and embankments, it's preventing soil erosion, creating level areas for buildings, roads, gardens, and parking areas, protecting structures from soil movement, and managing stormwater runoff and drainage. Interesting point that, and I'll get to that stormwater issue that on a recent claim that we had last year, and I'll actually brief you guys and give you in a nutshell what happened in terms of that retaining wall. And then common types of retaining walls.
Sorry, Billy, just to stop you there. Some people are saying that they can't see the images, but I'm not sure why that would be. But let's just keep going, because we're talking about the definitions and that type of thing now. We just carry on.
Correct.
And then once, yeah. Can everybody see this? It says, what height of soil must be retained?
Is that the slide that everybody is looking at right now?
Yeah, I think so.
Okay, I've got the definition slide on my side.
But it keeps showing co-pilot stuff. We can't see the full slide.
Okay, all right. Okay, let's leave that for the moment, Billy. I think let me just take you through my questions like we had planned originally, just to go through that. So as an insurer, you are the face of the insurance, the face of your brokerage. And at the end of the day, they can see it now, I think. At the end of the day, you have to approach your insurer to find out exactly how they're going to, or if they're going to cover the scheme's retaining walls. What kind of information do you usually need for that?
So first of all, Marina, this is one of the challenging topics, because 99% of times we don't always know if the scheme has got a retaining wall. So once we approach an insurer, we actually approach the insurer with the unknown. Currently, we're looking at the current policy schedule that's in place, and typically a retaining wall needs to be specified on that policy. And if we don't see a retaining wall that's separately specified on the policy, we would not know if that scheme has a retaining wall. So we can go back on the loss history, we can go back on the claims history, to try and pick up if there are any storm damages related to a wall or retaining wall. And in some cases, the claims history would not show that they had a claim on a retaining wall. It would merely just say that there was storm damage on one of the walls. So Marina, to answer the question, is we actually go in with the unknown factor to the insurer in terms of getting cover, getting quotations, etc. And that is our challenge, which we will unpack on a later stage during the session. How do we overcome the unknown?
Okay, and full disclosure. Let's talk about full disclosure, because that is such a favorite with insurance companies. What is full disclosure? I mean,
but you can give one of them.
At the end of the day, I mean, what are we talking about when we talk about, do they have to disclose damage, or what about age and the age of the walls? I mean, often trustees don't even know about these things.
Yeah, 100% correct, Marina. So full disclosure is typically what the word says, full disclosure. We need to have all information available at hand, meaning maintenance work that was done, photographs. I think somebody is not on mute.
Yeah, got it. They take themselves
Please
off
mute yourselves.
Please mute yourselves, everybody. Carry on, Billy, sorry.
So full disclosure, just getting back to, we need the schemes need to disclose all relevant information which they have at hand in order for us to approach the insurer. And that would mean past claims, it would mean past damage, maintenance works, photographs, whatever is available for the scheme at the time we need to know in terms of full disclosure. And full disclosure, Marina, doesn't mean only once. Whenever there's a change in the risk, whenever there's alterations being made to any walls, we need to be updated from a broker's point of view so that we can engage with the insurer to understand what is the risk that the insurer needs to underwrite, and that we can advise our clients at the end of the day in terms of cover. And I think that all boils down to non-disclosure means no claims. If you don't disclose any material facts, the insurer will reject those claims, and this is where our challenge currently lies in the industry. And I must also say, if I can just quickly mention it, I think at this point in time, Marina, we're playing the reactive game in terms of reactive on the claims that's coming in instead of being proactive. And we'll discuss that on a later stage.
Okay. So what questions do trustees need to ask the brokers? You guys are the guys who meet with the trustees, as I understand it. What kind of questions are you going to ask the trustees?
It's a very important question.
So I would assume it's at renewal time.
Yeah, so very important question. I would like to say this to everybody online. That's typically when I think somebody is still not muted.
We do try and mute from our side, but it looks like that. Yeah, carry on.
First and foremost, we need to engage with our client. And with all due respect, the managing agent and the property managers that's on the call is not our client. It is our client, but it's not our client. You must bear in mind that the policy contracts between the insured and the BC and the HOA. So we need to engage with the trustees on a yearly basis at renewal, Marina, and discuss certain terms and conditions of the policy. And this is where we will talk about the retaining wall structures in the complex. Because all insurers do exclude retaining walls unless specifically specified on the policy with an additional sum insured at a premium. We keep a record of advice. In our industry, we need to have a record of advice. So whenever newly trustees are getting elected, then they can actually request a record of advice. And in our record of advice, it would have everything that we've discussed with the client. And we've got a specific question in our record of advice pertaining retaining walls. Marina, so very important for us to engage with the trustees.
Okay, thank you. I'm going to go to Doug now. We'll come back to you, Vili. So from an insurer's perspective, Doug, what makes a retaining wall a particularly complex risk? You just need to unmute yourself.
Sorry. So the challenge with a retaining wall, it's a wall that's essentially fighting a very fundamental force of nature, which is water pressure. And to get this feat of engineering right means that you have to adhere to quite strict standards and quite lay down guidelines to actually build a wall that lasts for a long time. And unfortunately, because retaining walls are generally, we're not talking about retaining walls that are incorporated inside the building. These are more like garden walls and boundary walls. Retaining walls of that nature are often built after the building has been signed off, or they're not signed off by an engineer, and in a way they're not built to the same standards, and more often than not, they are not built to any standards, and they're just. I've got a good photo to show you about that, but that's what makes them quite complicated. They're essentially fighting this force of nature. They're doing something that nature doesn't like. It wants to. Water wants to flow, and ground wants to even out, and a retaining wall is pushing this back.
And obviously, you've got your different retaining walls for, they're different risks between a wall that's supporting a garden and a wall that's literally supporting a road, for example.
Yes, and that's where we definitely see a difference. So walls that that generally support roads, or that, for example, your house might have a retaining wall. Your house is on 2 levels, so a section of your house will have a built-in retaining wall. Those walls are, in our experience, much better built because it's part of the house. So the house, when a house is erected or a dwelling or a residential unit is put down, the engineering sign-off is a lot more strict, and you can't take chances. Even at the planning stage, you'll have to specify how the retaining wall is going to be built. These standards, there are standards available for retaining walls. They've been enforced since 1970. So a lot of it has been worked out. It's more the adherence to those standards that we find is a problem. If you want, I can just share a couple of slides and just to show you.
Let's try it. Let's try it and see, and just let us know if you can see it, guys.
Should take a
Few
few
seconds.
seconds.
Doug, while we're waiting for that, I want to ask you something. If a wall has been standing, like a retaining wall has been standing there for 30 years, often trustees, I hear them say, well, it's been standing there, it's stable, it's been there for so long, and there's nothing that we need to do or disclose or whatever it is. Is that reassuring that it's been standing for so long or not?
Unfortunately, it's a double-edged sword, and the problem is that buildings over time decay. So cement decays, walls especially become susceptible. So a common problem that we see with retaining walls is that it was never designed to be a retaining wall. So it will be a boundary wall that over time, over the 30 years that it was built, it's just been soil has been building up against it, and then vegetation or plants get planted. Small trees get planted with little roots, and then in 30 years it becomes a massive tree and the roots become massive. And so the challenge is that a wall that stood for 30 years could very well be closer to failure than a new wall. It's very difficult to say. So for our recommendations are to make sure that you have the walls properly inspected regularly. So every year, things to watch out for are moisture ingress, cracking, any loose plaster. There'll be telltale signs saying this wall is not happy. I mean, walls can often bulge, and I've got a few photos. So I just wanted to show, if everyone can see this one, this is taking, and I hope this is not someone's wall on the complex, because it's quite a scary situation where they've actually installed I-beams to push the wall back, but instead put it against the main building. So we're hoping the building is strong enough to withstand it. Just as we mentioned, the retaining walls are pushing back against nature, and there's very specific design recommendations, regulations. Just to show you the different types of retaining walls we come across: brick, concrete, gabion walls, Loffenstein walls. These are often used in South Africa. The problem that we have is that, if you can see this slide, retaining walls are often built by people that aren't qualified to build them. It's a very complicated piece of engineering, and if it's put in place by someone that can't even spell the word retaining, that can be a problem. And unfortunately, that is, in the slides that are coming, you'll see. But just to show you, these are the standards that affect retaining walls. It's a bit difficult to see there, but they were introduced, I think, in 1970. And they give quite clear guidelines of how thick the wall must be, whether there needs to be piers, how thick those piers need to be. The regulations were updated in 1990, a bit clearer there, you can see. But again, there are clear standards on how walls should be built. Unfortunately, and I've had this at my own property, they're just not built to the right standards, and that makes them very difficult to insure from a storm perspective. We do always insure them for impact and fire. All insurers will cover them as standard generally for impact and fire. This is a good case that we've had. One of our claims, a truck driving through the wall. No amount of engineering was going to stop that truck breaking through the wall, and hence in fire and impact claims, we tend not to concern ourselves whether it's a retaining wall or not.
Sorry, can I just ask you quickly, Doug? Lisa's asked a good question. Nice to see you on this platform, Lisa. She says, is there no obligation on the insurer to do an inspection prior to the issue of a policy and then to assume the risks it has seen?
So that's a good question with many facets to it. insurance contract is written on the basis that an insured presents their property to be insured. Insurers are not in the position, if you think about especially a body corporate, we're not in a position to go and inspect every single unit, every single wall, every single roof, every single thing. A lot of what we're insuring, we have to take, well, the only way to do it efficiently is to take that risk on the basis, the agreed basis that the building is built in terms of building regulations. And so that does it efficiently. The building regulations is the law of the land, and that specifies how you can and cannot build the property. So we say it's difficult for us, we're not qualified, and if we try to do it, it would make insurance unaffordable to send an engineer out every time we wanted to insure a policy to go through the policy and through the property in detail and check everything. We do fire surveys. That's something that we're able to do. It's efficient for us to do. But again, it's not something that absolves the insured of their obligation. Remember, insurance is a contract of good faith. It's a promise. An insured will bring their property to us on the basis that it has been correctly built and constructed, and we accept that, and we make the promise that we will, in the event of a claim, meet our obligations. And the way that promise is worded is in the insurance wording.
Tell me now, I want to know about engineers, because the engineers will play a big role when it comes to walls. I mean, just yesterday I spoke to a trustee about a matter in a complex where one of the owners has just put up certain structures and certain walls, and the trustees are saying, no, they don't comply with anything. And we were saying, well, actually, the trustees are not engineers. They can't really give their opinion on these things. So when do you require the assistance of engineers when you receive a claim?
So, well, at two phases. So engineers are invaluable in the construction process, and it's always a good recommendation to have a good engineer as a contact for the body corporate, or as a broker, or as a managing agent, or as a body corporate, to have an engineer who you trust, who can give you sensible advice. Our experience in South Africa is that our engineers are very well qualified. They're generally very black and white, so they're easy to. They find it easy to determine, what the lay of the land is, whether something's built correctly or not. In our cases, we would look we do insure retaining walls for storm, wind, water, and snow, but we require them that they add it to the policy up front. And in those cases, your engineer would have a design documentation, and he would have photos, and he signs it off, and he gives us those documents, and on that basis, we're able to insure the retaining wall. And we do insure many retaining walls throughout South Africa for storm, wind, water, or snow, on that basis that they have been signed off by an engineer. In cases where there has already been a claim and there's been the wall hasn't been specified, in certain cases we will appoint an engineer. If there's an area of grey or technical side to it that we're not able to obviously see for ourselves, we'd appoint an engineer, and we'd base our decision on the engineer's report. In certain cases, and this happens, and we accept that, another engineer will have a different opinion. And that is where we recommend our insureds to, if we investigate a claim and we appoint an engineer and he comes with a finding, the insured is always welcome to appoint their own engineer and get a second opinion. And in cases where that happens, we always are open for the two engineers to meet, and the engineers then, between themselves, the two technical experts must figure out what's right and what's not. And we found in 99% of those cases, the engineers very quickly come to an agreement of the right course of action, and we are bound by that. We follow that.
Thanks, Doug. I'll come back to you on the scope of cover. I'd like to move on to Alex now, and it may be an opportune time because Sue has asked about where trustees fit into all of this. So, Alex, I'm going to address these questions to you. So, I want to ask you your thoughts about trustees and good governance, because as we know, we've all been to the We Connect You Engage seminars, and we've heard how trustees can actually be a bottleneck to decision making, because it seems as though they're like startled rabbits in the headlights, not making decisions properly. What are your thoughts on this? Is there a compromise on maintenance and safety because of trustees' inability to act?
There's never a compromise, but good governance is about recognizing that as a trustee, you don't have to know everything. The responsibility of a trustee isn't to be an engineer. The responsibility is to recognize the problem, obtain professional advice, understand the risk, and then make a properly informed decision. So postponing maintenance doesn't necessarily save the scheme money, and I think that's where the misconception is with a lot of trustees. All that does is transfer that cost to a future date, and by then the problem has become significantly more expensive, and now it's potentially a safety issue as well. Trustees shouldn't be looking at the wall and thinking, well, it hasn't fallen down yet, so we're okay. They need to be asking, what is it retaining? What happens if it fails? What is the engineer telling us? And the problem that always delays them is, do we have enough money in the reserve fund? And half of the time, they really don't.
That is a massive problem. Can an ordinary boundary wall become a retaining wall suddenly because people are doing work? That's what I've seen over the years. Things change. People put up illegal structures.
Absolutely. And Doug touched on this already. It absolutely happens, and it happens more often than not. A practical example, as Doug touched on, was that an owner has a relatively low garden wall. The owners change over time. The privacy needs of the owners change, and the wall gets extended. Then years later, landscaping raises the soil level behind that wall by half a meter or so because the owner wants a nice flat garden, or somebody puts in a pool and they raise the garden level with the excess soil. They probably forget to put in the necessary weep holes. The wall is now retaining soil and retaining water. So its function has been fundamentally changed without anybody realizing it. And that process has been slow and gradual. The trustees haven't figured it out either.
How frequently do you encounter walls that haven't been, that are not on approved plans? Because as managing agents, you also obviously get the approved plans and have a look at what's going on there. Trustees are unaware actually of what retaining walls are. Why is that?
Well, the problem with the retaining wall is that they just think everything's a normal boundary wall, and they don't realize. They tend to judge the wall by its appearance rather than its function. They see a brick wall or a concrete wall and they think it's a lovely boundary wall. But the important question is, what is that structure retaining? Where is there a difference in ground level? Trustees, of course, aren't going into people's backyards with a little tape measure and seeing what the height difference is on both sides. But they do need to identify if something requires professional assessment. And as for not being on the plans, it's very common, unfortunately, particularly in the older schemes. As I said, the needs of the members change over time, and so the complex ends up adapting to meet those needs. If we look at those older complexes where there was only ever one car per household, nowadays it's 2 or 3 cars per household. So the trustees end up digging up the gardens to make extra parking, leveling out the land, and they unintentionally create a retaining wall without even intending to do so. But if there's any significant part of the complex that gets changed, then it should be listed as a retaining wall on the plans, particularly if the trustees are aware that they have implemented a change that significantly affects the complex.
And we talk about the compulsory 10-year maintenance, repair and replacement plan. How do you think that the retaining wall should be incorporated into that plan?
Well, I think it's a simple case of what would happen if the wall failed. So if we know that if that wall or structure had to fail, there's going to be emergency maintenance and exorbitant costs. So the trustees should be identifying where these problems are first and foremost, and then adding these to the 10-year plan. a perfect example is we've actually got a current situation. The wall inside one unit's garden, not the wall, sorry, the actual structure, the actual section wall, had a massive structural failure when the common property pool actually sprung a little bit of a leak. It washed away the foundation of the entire unit. And over years, they've rebuilt it up and they fixed everything. In the meantime, the unit had to end up being rebuilt from the foundation up. The family was displaced, and the other owners ended up paying a 1.2 million rand special levy for that wall to be rebuilt. But if something like this swimming pool and the retaining wall and the structure, if that was all on the 10-year plan, this would never have been the dramatical problem that it actually did end up being, that it ended up becoming.
Mm. Yeah, absolutely. I think I'm going to come back to you, Alex. I'd like to go back to Vili. So Vili, when should the broker actually be contacted in your view when something does go wrong with a retaining wall? Is there a certain amount of time? Is there a time period? What do the insurers say?
Well, Marina, we normally say, and I know things can't happen immediately, but within a reasonable time, you only got 30 days to lodge a claim to the insurer. And after 30 days, late notification comes into play, and we need to motivate why was it a late notification. And in a lot of instances, when a wall started showing a defect, you might not see the urgency of it right now, and you might keep quiet, and eventually when the big storm comes, the wall collapse. So we would rather say immediately, and immediately could be within reasonable time as mentioned. But as soon as you start notifying there's a defect in the wall, just alert your managing agent, and the managing agent will alert us. In a lot of instances, these schemes doesn't have the broker's detail to contact them directly, so they work through the managing agent, and they need to notify us as soon as possible so that we can actually get the specialized people in, get the contractors in, and then start treating the possible claim from there onwards.
And should the trustees avoid doing anything in between that time?
Marina, there is a part of the policy that caters for emergency repairs. So, you need to go have a look at what is the situation of the wall. If this wall collapse, and there is no entry or exit to the scheme, you need to start clearing out the site, but not throwing away everything, because the assessor needs to come out and assess the damage. So there is a part of the policy that you can start doing emergency repairs, but the emergency repairs is not rebuilding the entire wall. We had instances where it was because obviously if you look at a boundary wall and it becomes a retaining wall and there's a huge hole in the wall, it's a security risk for the scheme. So, you need to pull in the guys to make the decisions as quickly as possible, but that doesn't mean rebuilding the wall. There's other ways of means. There's also a part of the policy that cover guards, so you can get an emergency guard to guard the premises. So for the assessor to come out and inspect the damages, Marina.
And what documents, you as the broker will start lodging the claim, I assume. Just talk us through that process. Lodging the claim.
Lodging a claim would obviously mean we getting a contractor. First of all, the managing agent or the body corporate's trustees are getting a contractor in to do a quotation, getting a damage report done to see exactly what caused the damage, because we need to find out, is there cover on the policy? Was it damaged by an insured event? And the damage report will show that out for us. So together with a claim form that goes into the insurer, depends on the value of the claim, the insurer will appoint an assessor to go out and assess these damages. But together with that, we would normally get the contractor's quotation, damage report, and photos, if possible, in terms of lodging the claim to the insurer, Marina.
Okay. And is it a loss adjuster? What is that?
Yeah, loss adjuster is the same as an assessor. It's actually one and the same thing in terms of loss adjusters and assessors. Nowadays they talk about assessors, but in the olden days it was loss adjusters, but that's one and the same thing. As I said, that gets appointed once the insurer, and the insurer is the only one, Doug, and you can confirm on this, is the only ones that can appoint an insurer, because it depends on what's the value of the claim.
Yes, yeah, we'll appoint, depending on the value of the claim, we'll appoint an assessor who his function is to go and investigate what happened and what give us a report of exactly what has happened, what his best idea of what caused it, and also tells us how it can be rectified. Often it's the assessor, based on that initial feedback, who then will appoint an engineer if it comes back that there's something technical. Assessors are generally not, while they are generalists and they understand buildings and walls, they're not specialists. So anything of a technical nature, we'll appoint an engineer to investigate and confirm.
Doug, while I've got you here, I'd like you to talk us through this gradual and sudden event, because we all know insurance is about this sudden event. And I'm sure that a lot of people will be shouting down the phone and chair people and, where there's been repudiation by the insurance companies. And we'll talk about that with Vili, who's the broker. But when you say no to a claim, sometimes it's because it wasn't a sudden event. Just talk us through that, please.
Yeah, so there's a key distinction between damage that occurs suddenly. That's, for example, that truck. Let me just bring that up. Well, that's a good example of a sudden event that happened at a specific date at a specific time. Then there's damage that occurs over a period of time. These are things like cracks, moisture ingress. I've got a good photo here of roots and water seeping through. That type of damage permeates the wall over time. It degrades the wall, and the failure of the wall is then not a sudden event, because it's actually been damaged over a long period of time. It's similar to inside your house. It's a common problem. You have bubbling paint that rising damp just causing the paint to bubble and get loose. That's something of a gradual nature. And unfortunately, insurance is not designed. It's not designed. It's not priced to cover things that happen over time. The thinking being, obviously, that things that happen over time is the sooner you fix it, the better. And so where a wall cracks, or the first bit of moisture that enters a wall, or the first root that dislodges a brick, it's a lot cheaper to fix it at that point than to wait until the tree's 30 years old and it pushes the whole wall over. So that's the key distinction. So insurance is basically all based on events that happen suddenly and unforeseenly. And I suppose the other challenge with that is people often think that I need to have discovered the damage suddenly, but that's not how it works. It's the damage itself must happen suddenly. Whether you saw it suddenly or you only saw it much later, that is not the policy condition. The policy, the test. The test is that the damage itself is something that happens suddenly. Similarly, in the way of a car accident, that's a sudden event, and that is why insurance is able to cover that.
How would the insurance company treat earth movement, which can be sudden?
Yes, so subsidence and landslide has got its own special section, and there's a lot that goes into it. Our biggest claim that CIA's paid, which was Surfside in Umdloti with the floods there, where an entire bank of soil, collapsed, and 37 units actually collapsed into the beach sand. That was a good example of, the building is covered. Unfortunately, the sand underneath the building is never covered. The quickest reason for that is that the sand it's difficult to quantify how much sand is underneath your building. I've got another good example here, just from a retaining wall, which also talks to that, to earth movement. And this was one of our claims, and you can see here a gabion wall, the Cecil garage, and this gabion wall collapsed, and it basically fell into this extremely dangerous situation. And again, in cases like this, the the gabion wall wasn't covered, but the building itself was. And so that's also an important thing to remember, is that the actual damage to the wall is treated one way, but then your resultant damage, for example, to the building, I've got a few more here if you want to see. This was a very bad one. Also part of the Durban storms in 2022, where the wall collapses right through into a unit. It's an absolute chaos, very terrible. So in this case, again, the retaining wall is almost the small part of the claim. The damage to the unit is definitely that would be covered. And there it's generally we wouldn't be concerned about how the retaining wall was built, whether it was built to standards or not. The resultant damage that comes about is generally fully covered.
And what about removal of debris and that type of thing?
Yes, look, depends on the extent. I've got a good one here as well, where again, this is definitely it's prevented access. It's caused damage to the property. All this mud has to get cleared away. It's a lot of money, and these type of claims we are considered will be paid. Where it might be difficult is if it's just if it's fallen over in your garden and it's caused some disruption in your garden. That's not part of the building. It hasn't caused damage to the actual building, so that wouldn't be covered. Just to show, retaining walls, they don't always fail falling over this way. I've got an example of this. We had another one like this, and this retaining wall actually split open, and you'll see now. This is the one at the top, what it looks like, and how the water pushed and it just broke this wall open, like that.
Gosh.
And it moved right up against the houses. So yeah, it's retaining walls. They are a part of South Africans the building landscape, so we deal with them. And like I said, we do insure many retaining walls, and we're able to do it if the retaining wall is being built correctly to engineer standards. We will insure it. It is at an additional premium, which is not significant, but it is an additional premium. But then it is fully covered for storm. Otherwise, it's always covered just for impact. Yeah.
Thank you. Thanks, Doug. Alex, I'm turning to you now, and we're talking about let's discuss where these retaining walls are situated, because they can be situated on common property. In most cases, I think they are, but then they can also be within an exclusive use area, but it supports common property lower down. So what kind of practical difficulties do we see happening here?
All right, well, the first thing to do is that they're not obvious. A lot of the time it's not obvious. So the obvious thing to look for is any change in elevation. Walk around the scheme and ask, where does the ground level on one side differ materially from the ground level on the other? Look particularly at steep gardens, terraced gardens, walls between units at different levels, areas where the natural slope of the land has been cut into, going back to the parking bays, and areas where the soil has subsequently been built up. It's a wall that is supporting something other than itself. So, the best thing to do is what happens if the wall fails, and then from there you can identify where the problem is.
Where the problem is. So if we're talking about a retaining wall on an exclusive use area, obviously if it's a registered exclusive use area or even a rule created exclusive use area, it will say that the owner takes responsibility for maintaining whatever is on that area, but there's still common property involved because you're supporting maybe common properties. I think that's where it becomes a little bit tricky. Would you prefer it if the body corporate was responsible for these retaining walls? Because if you leave it up to an owner, that can also be problematic.
It can be problematic. But the fact that a wall is physically inside an exclusive use area does not by itself answer the responsibility question. You need to establish where the ownership lies. So what is common property? What is the exclusive use area? What does registered documentation say? So And also, who caused or altered the condition of that wall? So if you go to Section 3 of the Sectional Title Schemes Management Act, it places responsibility for common property maintenance on the body corporate. But Section 3.1 also specifically recognizes that owners with exclusive use rights may have additional contributions for maintenance of those areas depending on the circumstances and the rules. So once we've established the legal status and the physical function of the structure, then and only then can you actually determine responsibility. But yes, it would be nice to have a blanket rule that just says body corporate's liable, because at least then the trustees have a level of control.
Well, let's talk about levels of control and the trustees. I'm sure that you've encountered trustees in the past who've said, we simply don't have enough money. You've pointed out maybe that they're retaining walls, that there are things that need to be done from an insurance point of view, but there's not enough money in the reserve fund. How do you as a managing agent deal with that situation?
Well, the biggest problem is if the trustees keep saying, we'll look at it next year because the engineer is expensive, the managing agent needs to formally record the concern. It needs to be put before the trustees. We need to recommend professional assessment. We need to explain the potential consequence of delays, and we need to ensure the matter is properly minuted. The managing agent should not simply participate in the indefinite postponement, because we've also got a fiduciary duty to the scheme. At the same time, the managing agent cannot unilaterally spend body corporate monies outside the mandate just because we believe the engineer is required. So the important distinction is the managing agent facilitates and advises, the trustees govern and resolve. But the trustees cannot ignore their statutory responsibilities just because something's expensive. The Sectional Titles Act requires that body corporates establish and maintain the reserve fund for future maintenance and repairs of common property. It provides that the reserve fund is used for these kind of things. But if there genuinely isn't enough money, the trustees need to consider raising the special levy. Lack of funds is a financial problem that can be solved. It isn't reason to ignore a known structural risk.
Yeah, absolutely. And I think the liability on trustees, again, it's not the managing agent. It's not going to be the insurer. It's not going to be anyone's problem. It's the trustees. Actually, the ultimate responsibility lies with those trustees. So
Yes.
usually we at 45 minutes we have gone over time, and I'm happy to continue a little bit because it's really interesting, and I've got more questions. Vili, I want to ask you, what is the single most common misunderstanding people have about the role of the broker?
I think, Marina, if you look at that question, I think the most common one would be everybody think we are the decision maker. The ultimate decision making lies upon the insurer. We know we're not an engineer, we're not a building inspector, we're not a plumber or an electrician. So we merely facilitate in terms of the policy, and we act in an advisory capacity to tell people and our clients what does the policy wording says and what does the cover says, what are the exclusions, what are the excesses. So yeah, I think the most common one would be everybody thinks we're the decision maker and it lies upon ourselves to make the decision. And that's what we picked up in the industry, Marina, more often than not making a decision. So yeah, I would say that is the most common aspect.
I've often wondered about telephone conversations between you guys and the underwriters like CIA. Does it often get a little bit heated when you don't, when CIA tells you that you're not covering something? Because isn't it your job, Vili, to then go and talk to the trustees about this? To say the claims.
It's definitely our job, because the insurers don't get involved with the rejections. We have to speak to the client, Marina. And I just want to mention this. As a broker, we definitely do motivations. We look at the merit of the claim. We gather informations. It's not just that we're sitting back and says, okay, the insurer rejects this claim, pass it on to the trustees. Sorry, you don't have cover. It's rejected. We need to advise our clients why it's been rejected. And in some cases, we do a lot of motivations. In some cases, I want to actually take us back to a recent claim that we had last year on the West Rand with an HOA. It was a fairly big claim. It was in the sum of about 580,000, and the claim was partially rejected in a sum of 220,000, and that was a retaining wall. Nobody knew that they had a retaining wall. The plans didn't show retaining walls. The valuation didn't show retaining walls. So what we did is we went as far back as when the policy started incepting the first place with an insurer. And there was nothing mentioned about a retaining wall whatsoever. We've done a motivation to the insurer. They stood firm by their rejection. The case went to the Ombud, and the Ombud ruled in favor of the insurer purely by the retaining wall was not covered. We then actually got to an engineer. Engineer went out, he did an inspection, and he picked up that there was a retaining wall. The height of the retaining wall was 1.4 meters. At the time, the wall was constructed 100% perfectly to retain soil, but it wasn't constructed to retain water. And the water pressure made the wall collapse. And based on that, the claim. So yes, Marina, it's not that we do not motivate these kind of things. We get involved as much as possible. But I must also say, being a broker, looking at the policy, we also need to look at each claim on merit. And if we want to try and motivate building regulations, if a wall wasn't built according to building regulations, it's very challenging to motivate that to an insurer. And obviously, if a retaining wall is not covered, it's very difficult for us to motivate to the insurer to provide cover where the client initially never had cover. So we're facing those kind of challenges on a daily basis. And we work along our insurers, and I must say, we're building a very good relationship with our insurers, and if we need to have a heated discussion with them, we're fighting for our clients at the end of the day. And I think the insurers also knows our role, but we also need to be fair, and we also need to give best advice.
Thank you very much, Billy. Doug, it seems to me as though your job is easier then.
No, not at all. I must say that what Billy says is true, and that's the value of a good broker, to know. A good broker will know when the insurer's made a mistake, and we do make mistakes and we do miss things. And a good broker will know where to fight and how to fight. And that's why they are worth their weight in gold in terms of knowing that this is something that shouldn't be treated like this, and how far to push it in and which are the correct channels. It is a difficult. There are certain things that are difficult. Retaining walls is just one of those things. Like I said, it's a force of nature. That water pressure, it's not a question of if it will fail, it's a question of when it will fail. And that's the ultimate problem with why it just can't be included and just be insured like a normal wall. It's a lot more complicated, and that does cause a bit of uncertainty. But again, we do, for us, we rely heavily on engineers when it comes to these type of grey areas. Engineers will tell us, and we try and be as transparent as possible to, and that's where if an insured has got a different opinion or an engineer, and often there'll be an engineer living in the complex that will say, no, this is nonsense, let me go and figure it out and right. We've got to be balanced and fair. We also are not technical experts. We're not engineers. So we've got to be guided by their guidelines.
Thank you. Alex, you are sort of playing a role in this tripartite relationship as well as the managing agent. Tell us your experience working with insurers and the brokers.
It's always good to have a great relationship with your brokers. And I think if we all continue to be on the same page, it's going to work out great. At the end of the day, we're the middleman between the client and the broker. So we're just the middleman, and we need to make sure that it's open lines of communication, however it goes. We need to make sure that our mutual clients' interests are protected. So we need to make sure that if there is something that needs to be covered or needs to be investigated, the trustees are aware of it. They have to know it. They have to document it. They have to inspect it. They have to fund it. Because by making sure the trustees have those things in place, it's so much easier for the brokers to be able to justify insurance claims as long as those 4 principles have been put into effect.
Thank you. Thank you so much. I really appreciate that. And I really appreciate all of you being on here on this platform today. Quick thing, just talking about 4 principles for our attendees, we always recommend certain books as well, just off the subject. I attended Adrian Gore from Discovery's book launch yesterday called The Four Principles. Excellent book. If anybody wants to read a great book about leadership and about being inspired, all our ladies, and I see there are a lot of men on our webinar today. Men who support women are always welcome on our Women in Sectional Title webinar. Vili, Doug, Alex, you've been great. Thank you so much. We appreciate your insights. It's been incredibly valuable. We could be here all day actually talking about insurance. We have noted your questions, and we certainly will try to get back to those people. If you'd like to email me on marina@bbmlaw.co.za with those questions again, it'll help me tremendously, and we'll try to answer them, or to get our team, our panelists, to answer. So thank you very, very much, everybody. And we look forward to seeing you all next month. Thank you and take care.
Thanks, everyone.
Thanks, Marina.
Thanks,
Cheers,
Ed.
guys. Thank you
Cheers.
very much.
Bye. Thank you.
Bye-bye.
Thank you, everybody.